right, Chapter 9, Discretion and Dilemmas in the Legal Profession. So again, we're going to be talking a little bit more about attorneys and stuff here as opposed to law enforcement. So let's get in here. Learning objectives, blah, blah, blah. You can read this. Ethical issues for defense attorneys, which we kind of just talked about in the last chapter, but we're going to talk a little bit more about it. Defense attorneys are often in the position of defending clients that they know are guilty. A lawyer is supposed to assist their client without regard for personal preference or interest. People with unpopular cases and individuals who are obviously guilty still deserve counsel. It's a tough spot to be in. I would not want to be a defense attorney. It is the ethical duty of an attorney to provide such counsel. Attorneys cannot abandon their clients unless, and this is exactly what this exact same slide was in the last chapter. These are the reasons why a defense attorney could leave their clients. Specialty courts. We have things called like drug courts, mental health courts, or behavioral health courts, veterans courts, things like that. They're very common right now, but typically in order for a person to participate in those courts, they have to admit guilt, which is kind of, it's just part of the deal. So it's tricky because the defense attorneys usually have to talk their client into admitting guilt. So that's something that's kind of tricky for defense attorneys to basically they got to talk their client into admitting guilt, even if their client doesn't want to. Anyways, because they have to accept help or treatment in order to participate in those types of courts. Like drug court, you admit that you're a drug addict and you say, okay, I will participate in this drug court and drug treatment, and if I finish everything like I'm supposed to, then my case will get dismissed and sealed like it never happened. So anyways, is that a conflict of interest? I don't know. Attorneys, let me see. If a heavy caseload compels an attorney to advise his or her client to accept a plea bargain instead of going to trial, has that attorney violated the prohibition against the conflict of interest? I mean, think about that. If an attorney basically says to himself, not to his client, I simply don't have time to try this case, so I'm going to try and talk this guy into accepting a plea. Is that a conflict of interest? I would argue, yeah, that probably is. But at the same time, when you know that not every case can go to trial, I mean, really, honestly, truly, there's just not enough time. There's not enough space. There's not enough courtrooms. There's not enough judges. There's not enough juries. Our court system simply can't handle all the crime that occurs. Plea bargaining. Vast majority of cases are resolved by way of a plea bargain. The vast majority. Somewhere upwards of 95% are resolved by way of a plea bargain. Most cases do not go to trial. The vast majority. Defense attorney's goal in plea bargaining is to get the best deal possible for their client. Defense attorney is aware that he or she cannot aggressively push every case without endangering an ongoing relationship with the prosecutor. Typically, what happens is the same prosecutor and defense attorney will work in the same courtroom for a decent period of time, let's say 6 months. They'll each be, the same prosecutor and defense attorney would be assigned in Department 30, let's say. I'm just throwing that number out there. Is it important that they get along? Of course it is, because nothing gets done if they don't get along. So it's also important that the attorneys work well together. So there's a lot more to this than just working out one case. Defense counsel must zealously defend client, but not commit unethical acts to do so. They may not engage in motions or actions to intentionally and maliciously harm others, knowingly advance unwarranted claims or defenses, conceal or fail to disclose that which he or she is required to by law to reveal, or knowingly use perjured testimony or false evidence. They cannot make false statements. They cannot participate in the creation or preservation of evidence when they know it is false. They cannot participate in illegal conduct. Aggressive advocacy sometimes involves the use of ethically questionable tactics. Doesn't this sound like it shouldn't be something that takes place in a courtroom? But it does. And like I said, I've seen it happen before. I've had an attorney turn around. We had a case, a young man, he had turned 18 by the time this case went to trial. And it was a serious case. It was a DUI with serious bodily injury. And I had written the probation sentence, the sentencing report, and I also happened to be the probation officer in court that day. And I was arguing for this young man to do some custody time, probably, I don't know, a year or so in custody. And it was not his first DUI, and he clearly was a danger to the community. And I was arguing that he needed to do some time in custody along with a substance abuse treatment program and blah, blah, blah. And the attorney we had a visiting judge that day, not our normal judge. And the attorney turns around and in the middle of court with a visiting judge says that Officer Fernandez is clearly simply racist and does not like Native Americans. And I was completely floored, horrified, shocked. First and foremost, I had no idea that the defendant was Native American. I had no idea. Secondly, I couldn't believe that someone would call me racist on the record in court for absolutely no reason. Thirdly, again, I was like, oh, wow. I had no idea that this young man was Native American. Anyway, it was an absolute ploy tactic to try to kind of dissuade or make the judge think something differently of me, because the judge didn't know me. Like I said, we had a visiting judge that day. All kinds of crazy stuff happens in court. Of course, I objected, and the judge made him apologize to me on the record in court that day. It was horrifying. I was completely disgusted, and the kid ended up going into custody for whatever period of time I asked for. But anyways, crazy stuff happens in court. Next, jury consultants. Okay, you all know who Dr. Phil is. So before Dr. Phil was Dr. Phil on TV doing his crazy show, he was a jury consultant. And what he would do is basically his job was to pick juries. He would choose juries that would be most beneficial to the defendant. So this was his job. This is the kind of stuff he did. He'd prepare witnesses, assist with mock trials, develop desirable jury profiles. He would actually go into the courtroom and help them choose which jurors would be best for the clients. Giving advice on posture, clothing, tone of voice, all that kind of stuff. So jury consultants are completely legal. They had them in the O.J. Simpson case. There's a show, and I can't remember what it's called, but it's a TV show that's on like NBC or something that talks about jury consultants, and they are completely legal, and they could be used in any courtroom at any time. Confidentiality. You are probably all very aware of attorney-client privilege. There are some times when the attorney can share information, and these are those times. Skip through that. Perjury. Perjury would be lying on the record in court. So when you go to testify in court, you swear to tell the truth, the whole truth, and nothing but the truth. If you lie while you are testifying in court, you can be charged with a crime called perjury. So an attorney should not participate in assisting their client in perjuring themselves. It is the attorney's job to make sure their client does not perjure themselves. If the client does perjure themselves, the attorney then has an ethical duty to withdraw from the case. Now, if the client does perjure themselves, there are two different ways an attorney can be involved. Now, if the attorney assists them in perjuring themselves, then the attorney can be held responsible and be disciplined for that. If they do not assist in that, then it's considered passive, and the attorney can't necessarily be disciplined for that. Prosecutors also, there's ethical issues that can take place with the prosecutor as well. They should seek justice, not convictions. They should seek justice, not conviction. They shouldn't be trying to win the case. They should be seeking justice. This is not necessarily how it goes. A lot of attorneys want to win. They want to win at all costs, as opposed to just seeking justice. They do have a lot of discretion. They do not have to charge everybody that commits a crime. They are also very political beings. You'll note that I think one of our discussion questions recently had to do with the current DA, who is Lisa Smitkamp. And I posted a statement where she kind of went in on Governor Newsom about zero bail. She's a very political being. She is elected, so we, the people of Fresno County, vote for her. So being an elected political being does have an impact on, could have an impact on how people are prosecuted. So those are some things that could impact ethics. In she might consider her next election when she is prosecuting people, and not just her. I'm not trying to point her out. I'm saying any DA. Any DA could consider, well, how will this look for me when I'm up for election? A lot of times that's especially important when there are capital cases or death penalty cases. We're all probably, hopefully, you're aware that the death penalty, we have a moratorium or a hold on all death penalty cases right now in California. Governor Newsom, when he came into power a couple years ago, decided to halt the death penalty. So it's not, how do I say, there's a moratorium on the death penalty, which is in effect basically as long as Governor Newsom is governor. So we shall see. Although the DA's office, the prosecution, is still going forward with capital cases. At this time, nobody will be put to death in California, at least as long as Newsom is governor. The DA, again, we're still starting with DA, or district attorney is what I mean when I say DA. That is the prosecutor. Those are the people that are prosecuting the criminals. They have a duty to give all of their evidence to the defense. Duty to disclose. That's what we're talking about in all this. All their evidence needs to be given to the defense. That's what a Brady motion is. We talked about most of this. Not particularly important. Asset forfeiture. I think, well, we didn't, yeah, we did talk about it in this class. Asset forfeiture is something that it's can get muddy as far as ethics is concerned, and it is sad. Sometimes, you know, drug dealers screw over their parents, and their parents lose their homes because the drug dealer has leveraged their parents' homes, and asset forfeiture comes in, and goodbye to mom and dad's homes. Plea bargaining. Is there serious ethical concerns sometimes with plea bargaining? Absolutely. There can be. And these are some reasons why. A lot of it has to do with efficiency. Attorneys simply don't have time. They simply don't have time. And they will plead a lot of cases down. And this happens in both the prosecution or DA's office and the defense attorney's office. It happens throughout the court system. And it's not just one or the other side's fault. Media and their involvement with the courts, that's a whole other issue. Expert witnesses. This has always been one that's been super interesting to me as far as conflict of interest. You can have two doctors come in and say two absolutely opposite things about the exact same case, each paid by the opposite side. So you'll have a prosecution doctor come in and say, there's absolutely no way this guy died of a heart attack. It was murder. And then you'll have a defense doctor come in and say, this was absolutely a heart attack. There's no way this was murder. Each one is being paid by an attorney. So how can you say that there's no conflict of interest there? I don't know, but lose credibility after gaining a reputation as a hired gun. There's a lot of expert witnesses that, you know, if they're being paid by an attorney to say something, sometimes they lose credibility. You all have probably seen CSI. The whole concept of CSI and those TV shows has basically ruined a lot of juries because people expect that court cases are going to look like what happens on CSI, and it is very much not like that. These are some of the fields of study in CSI. Fingerprint analysis is really interesting because you'll see, I have a friend who does that, and it's nothing like what they show on TV. Absolutely nothing. It's very interesting. Zealous prosecution, just like zealous defense, tactics such as using witnesses with less than credible reasons for testifying. Prosecutors want to win. They all want to win. Jailhouse informants are something that a zealous prosecutor might use. Sometimes a jailhouse informant just wants to get out early. Sometimes people will be paid for testimony, not with money, but with, well, I guess it could even be money, but for reduction in charges. Judges also can have a conflict of interest. And judges, if they're is a conflict of interest should recuse themselves. Where is that? Oh, there's recusal. If they know somebody who knows somebody, in a town like Fresno, it's a big town, but it's a small town, and a lot of people know a lot of people. So if a judge knows someone's, sister, cousin, wife, husband, brother, whatever, always a good idea to back out. Then you got discretion. Judges have a lot of discretion on sentencing. And I can't remember, again, if it was this class, because again, I have 6 classes. I always forget which class I did what in, but we had the case with the Stanford swimmer who raped the unconscious girl. And he ended up getting 6, he was convicted of rape of an unconscious woman, and he ended up getting 6 months in jail as his sentence. And that was a use of discretion, and the judge was within his right. He had the power to only give the young man 6 months. And ultimately, because of good time, work time, the young man did 3 months in jail. 3 months? 3 months in jail, 90 days in jail for rape. That discretion definitely can raise some red flags. So, are there inconsistencies? Are there certain people, maybe of certain color, that get more harsh sentences than others? Maybe a Stanford swimmer got less than somebody else might have? Yeah. And here are some discussion questions.